I know the votes have been counted, and most of the bills, especially at this late stage of the session, are done deals. But please listen to me today as to why I think this bill is fatally flawed. First, I need to talk to you about what a grand jury is. A grand jury is not the jury you see on the news that just found a police officer not guilty of using excessive force. It is not the jury that is unable to convict someone famous or rich like Bill Cosby. Those are trial juries and nothing like the grand jury. A grand jury is made up of 7 citizens and a deputy district attorney who is there to help direct the procedure. Of the 90 Oregonians in the legislature, I doubt if more than 5 of us have ever been in a grand jury. I'm one of those who has appeared before a grand jury on numerous occasions, but I was a police officer, a professional witness, if you will, and that makes a real difference. The grand jury reviews evidence, usually brought by the police and the prosecutor, to determine if there's enough evidence to take a case to trial. That's a first blush look at the evidence, prima facie evidence. It helps the grand jury ask if there's a probability that a crime has been committed. If the answer is yes and there's enough evidence to proceed to trial, they will return a true bill and then indict the suspect on the appropriate charge. Virtually all states record grand jury proceedings in some manner, but most allow a case agent or a police officer to testify in the place of a crime victim. Just for context, it's important for you to know that the federal grand juries allow case agents to testify as well. Senate Bill 505B requires an adult victim to testify in person, to have that testimony recorded and made available to both the prosecution and the defense for case trial preparation. And I want to state here clearly that I'm getting ahead of myself here. The defense attorney can review the recording with the client. They cannot make a copy or let anyone else make a copy, and the same is true for the prosecution. The recording is protected, but the suspect will be able to, in the presence of their attorney, listen to the recording. So what's the problem? The issue here is that the victim will be giving their statement to the grand jury, and that will be used during trial to possibly undermine their testimony. If they're lying, I don't care if it undermines their testimony, but if they're telling the truth, there's other problems. Let's review again what the grand jury is. 7 citizens and a deputy district attorney or district attorney. Please try to see this from the perspective of the victim. They've been severely traumatized. In fact, I appreciate this was that they removed from the original bill the part where a juvenile would not have to testify or would not be recorded. A juvenile's testimony is not going to be recorded, and that was a big asset to this bill. But for the adult who could be a sexual assault victim, a victim of domestic violence, or someone who's been molested over several years and is now bringing the case forward as a young adult, they will be recorded. I know that the district attorney can apply for a protective order and say, you know, don't release this, and a judge can say yes, and a judge could also say no, release it. So I want you to think for a minute, if you are a victim of a violent crime, something that happened recently or repeatedly over the years, you're understandably anxious and you have no idea what's going to happen at that grand jury. You show up at a courthouse and you're directed to a room where a grand jury is in session. If you're from a small town in rural Oregon, you may well find friends or neighbors who know you on that grand jury. If not, you might find yourself in front of 7 strangers and a deputy district attorney and are asked to tell about the trauma you just experienced. You will be alone in front of that grand jury. You cannot have a loved one. You cannot have a friend. You cannot have an attorney with you. You will be alone and probably feeling very vulnerable, and understandably so. Those members of the grand jury may now ask you anything they want. These are not trained lawyers. They are not trained in the law. They can ask you very intimate questions about the crime or your state of mind at the time. They
Representative, excuse me, one moment. Representative Reardon yields his time. Please continue.
They might ask you personal questions that may or may not have any bearing on what happened to you. Remember, the grand jury is made up of citizens like you who may well not be familiar with the niceties of our judicial system.